Good day everyone, you welcome back to another episode of Criminal Law Class. This is Ibrahim Damilare. If you are just joining the class, make sure you click the notification button to subscribe to this channel for more subsequent videos on criminal law and other major courses in law. And make sure you like my videos, make sure you share and comment. Thank you so much for your support. So in today's class, we'll be talking about the criminal responsibility as an essential aspect of the crime. We'll be talking about the Actus Reus and the Mens Rea, causation and concurrence. Okay guys, let's start with criminal responsibility or the criminal liability. When we say criminal responsibility in criminal law, we mean the elements or the fundamentals of a crime which are incumbent upon the prosecution to prove in a criminal charge. And upon proving these elements, the court will consider such a criminal case. In a criminal proceedings, the prosecution bears the burden of proving the accused guilt beyond reasonable doubt as required by Section 36 of 5 of the 1999 Constitution as amended. This is in pari material with Article 11 of UDHR 1948. Altogether, they presume the accused innocent until proven guilty. This standard is further reinforced by the provision of Section 135 of Evidence Act, which mandates that the prosecution evidence must be strong enough to eliminate any reasonable uncertainty about the defendant's guilt. In the case of Charles Egberika v. State 2014, the court held that the prosecution must prove its case beyond reasonable doubt, emphasizing that any iota of doubt or shadow of doubt must be resolved in the favor of the accused. So from the foregoing, we can establish that before the prosecution will establish their case before the court, they have to prove the essential elements, and this is just the onus that lies on the prosecution. They have to prove all these elements beyond reasonable doubt before they can secure the conviction, which is the major goal of the prosecution. And they being unable to prove these elements, they cannot secure the conviction, because the court is always reluctant to charge a person for an offense if the prosecution is unable to prove their case before reasonable doubt. And that is why they do say something that it is better to free 100 people than to jail a person, because the court is always very reluctant to jail a person if that person has not committed the offense. Also, in the case of Orison versus People of Lagos State 2019, the court reaffirmed that the burden of proof lies entirely on the prosecution and the standard is beyond reasonable doubt and not beyond every shadow of doubt. So this case further reinforces or further clarifies the provision of Section 135 of Evidence Act, which places the onus on the prosecution to prove their case beyond reasonable doubt, and this is what we know as the standard of proof. So it is always beyond reasonable doubt. It is an objective test and not beyond every shadow of doubt. That means the prosecution does not have to prove the case beyond every shadow of doubt. If they are able to prove the case beyond reasonable doubt to make the court believe that this person has committed the offense, then they will secure the conviction, which is the major aim of the prosecution. So let's continue with the element itself. Before we go to the twin elements of a crime, it is good for us to consider the historical antecedents or the historical significance of the two elements. So early law treated crimes as offenses against the state and God, focusing only on actions, not the intent. By the 15th century, severity persisted until petition for mercy led to the maxim that goes thus: actus non facit reum, nisi mensis rea. An act does not make a person guilty unless the mind is also blameworthy. The meaning of this maxim is, or the meaning of this principle is, it's just that an act itself, that is the Actus Reus, does not make a person blameworthy unless the mind is also blameworthy. That means the act and the mind and the guilty mind must go together. So this just to establish the principle of Actus Reus and the Mens Rea. So what this historical background is just telling us is that before, all the offenses were treated as strict liability offenses or absolute liability offenses. Once you've committed a crime, there's no need for the court to be looking for your guilty mind. So far it is glaring that you committed an act or you killed someone. So far you had intention of killing or it occurred by accident, none of those things will be declared to be material, so they'll be seen as immaterial. But with the development of the law, we came with new developments that there should be a kind of guilty mind. A man should not be convicted for only an act without the guilty mind or without proving the guilty mind. So the two elements, we have the Actus Reus and the Mens Rea. So the Actus Reus means the physical element of an offense, and it may be constructive or it may be direct in nature. We have the forms of Actus Reus or the types of Actus Reus, and the first one is the act. So the act constitutes the external element of a crime, and it may be in any form. It may be in form of eating someone, beating someone, killing someone, raping someone. So altogether they constitute the acts or the criminal acts which forms the external elements of a crime known as Actus Reus. So the second one is the passive state of affairs. So doing nothing also can constitute an offense called vagrancy. This is an offense under section 405 and 406 of the criminal code, then other section 249 and 250 of the criminal code. So another thing that can constitute Actus Reus is the initial act or other factor. In the case of receiving stolen property, you have to establish that that item was stolen and the person that actually received this stolen property had the knowledge that it was stolen. So this is the position of the law under section 316 of PC and section 427 of criminal code. So the last one, the last form of the Actus Reus is the omission. So omission is the failure to do a particular act when you are bound by law to do the act. So the law does not enjoin you to be charitable and good, but the law prevents you from doing harm to other people. An omission to do an act will not be a crime ordinarily unless the doing of such act is a duty imposed by law. So for example now, if Mr. A does not give food to Mr. B and Mr. B dies, so no liability will be cast on Mr. A because he didn't give food to Mr. B. The only condition or the only instance where Mr. A will be held liable is when Mr. B is an infant that is depending on Mr. A for survival. That is recognized by the law. So in that instance, Mr. A will be held liable. So if someone is a beggar and is begging you for food, you didn't give the person food and the beggar dies, nobody will hold you responsible. No liability will be cast on you. You can only be charitable on the basis of humanity. But if the law does not impose a duty, you are not actually bound by law to act. So in that instance, nobody can hold you liable or responsible for such act or for such omission to act. So this was held in the case of Akoni versus State, and this is the locus classicus on the justification of omission if it is not imposed by law. Okay, this is the fact of the case. So in the case of Ralph versus Akoni, the members of the crowd were just standing aloof or they were just standing by, and they knew that a house was burning, and inside that house there was an old man, one hopeless old man for that matter. So they didn't do anything, they were just standing aloof, and the house got burnt, the woman died. So after the incident, they were all charged with murder, and the court held that they were not liable, that no liability could be cast on them because they only acted disgracefully and their acts were just ignominious, but no liability was actually arising from what they did. So the court established a principle that a bystander is not liable for an omission, or a bystander is not liable for any crime if there is no any duty imposed on him to act. So in the case, it was just held that they were not liable. We have several sections of penal code that is imposing duties on the people, starting from section 136 to 150 of PC and several other sections. Then section 305, 300 and section 344, and several other sections of criminal code. So we have several types of omission. So we have several instances where the law is imposing duties on the people. So the first one is the duty imposed by the contract. So this one, if our two parties they enter a contract with consensus added them, so all the agreements they have, all the terms of the contract are meant to be kept. So failure to perform this duty or failure to keep the agreement is going to result in an omission, and that omission is going to cast a liability on the party that refuses to perform the duty. So this was what happened in the case of Ralph vs. Pittswood. A gatekeeper left his duty, and that led to the accidents. People died, and he was charged with murder, but the court later convicted him for manslaughter. So the same thing happened in Actus Reus Mens Rea, where a man left his duty and that led to the demise of the people. Also in the case of Actus Reus Mens Rea, so they have similar facts. So this one is just the omission of the duty imposed by the contracts. The next one is the failure to perform duties imposed by law or the statutory obligation. So the law imposes some duties which a person is bound to perform, and an omission to perform this duty may constitute the Actus Reus of an offense. So for instance, an omission of a public officer to perform his duty will amount to an omission. So failure of an individual to obey the law and order or to obey the order given by the public officer can also amount to an omission. Failure to produce the documents to the public officer. So generally, law can impose duty on you, like to perform several things. Mostly this duty is majorly imposed on the public officers or on the people while dealing with others in the public. So generally, failure to perform this duty will amount to an omission. We have several cases to explain the duties imposed by law, and the first one is the case of Ralph vs. Faith, where a medical doctor failed to perform his duty diligently and was held liable. So the same thing happens to the police officer in the case of Ralph vs. Dietam, where he failed to perform his duty, was also held liable. So in Ralph vs. Brown is another case entirely, where a member of the public was asked by the police officer to assist him in forestalling or stopping a riot, but he refused to help the police officer and he was held liable and guilty for aiding and abetting. So this position has been given judicial blessing under section 150 of Penal Code and section 200 and 201 of Criminal Code. The next one is the failure to perform an assumed duty or duty under special relationship. So the law imposes certain duties which are meant to be performed under certain special relationships. For instance, in a master-servant relationship or employer and employee relationship, section 302 of Criminal Code imposes some duties on the master or the employer to take care of the employee. Also, the parent and children relationship under section 301 of Criminal Code, this section imposes some duties on the family head or on the mother and the father to take care of their children, and their failure to perform this duty will amount to criminal liability because it constitutes an Actus Reus of an offense. We have forms of an assumed duty, and the first one is the parent duty to a child. So parents are inherently responsible for their child's care and well-being, and their failure to fulfill this duty is going to amount to the criminal liability. That was what happened in the case of Ralph vs. Gibbons and Proto. So in this case, a man and his wife neglected the child from the previous marriage, and that led to the demise of the child. When the child died, both of them were convicted of murder, and the court held that they were liable for an omission to take care of the child. So in the subsequent case, the court held that if a child is up to the age of 18, the parents will not be held liable for any omission because they are not owing any duties to that child again because the child is already up to the age of majority. Another one is the relationship that exists between two spouses or two siblings. So if there is a kind of, the law will presume that if you are the two people that are spouses or they are siblings living together, they owe certain duty to each other or to one another. In the case of R vs. Eastern, A young woman was held liable for murder because she failed to perform the duty she owed to her sister under special relationship between them. Another instance is jointly engaged in dangerous activities. So if two parties participate in a dangerous activities, they owe legal duty to each other or they owe duty to each other. That was what happened in Lewin and CPAs. A friend failure to act led to the death of another friend in a hot car. So in this instance, the court order it was not liable because the act they engaged in was not considered dangerous. They were able to prove that the act was not dangerous. If it was proved that the act was dangerous, then the friend would be held criminally liable. Another instance is ownership or control of the property. The law imposes duty on the property owner to prevent crimes on their premises. So if a crime occurs or someone dies in someone's premise, the person can be held liable for aiding and abetting. And that was what happened in the case of Talk and robbed scenes. The next one is the continuing act. So in this instance, if someone has caused inadvertently or knowingly, so when that person becomes aware of what he has done or what he has caused, he has the duty to stop that thing or to forestall that thing, and failures to do that is going to amount to the criminal liability. And that was what happened in Fagan versus NPC. So a man is very arrogant in nature, was having an argument with a police officer, and he didn't know that he parked his car on the policeman's foot. So when he got to know, he didn't even do anything to it, and he was held criminally liable because the failure to act in that instance amounting to criminal liability. The next one is the creation of danger. When someone creates a danger or someone creates a dangerous situation, he has the duty to forestall it or to mitigate it before the thing gets escalated. So that was what happened in the case of Ralph versus Miller. So in the Ralph versus Miller, this man he went out to drink, and when he got back home he was smoking cigarettes and he slept off. The house got burnt and he woke up, he got to know that the house was burning. He didn't do anything, just went to another room to sleep. The court held that he was criminally liable for such omission. That is all about omission. We can just conclude that omission simply means failure to perform the legal duty or failure to act when the law imposes a duty. So from this, we can say we've concluded on the Actus Reus, and we have to go to the next element of a crime, which is the mens rea. So mens rea is another important element of a crime, which means the guilty mind. So to establish criminal responsibility, there must be another element that is called the mens rea. It is also known as criminal knowledge or criminal intention, and it constitutes the internal elements of a crime. If you could still remember in our magazine, we stated that an act alone does not constitute a crime unless the mind is blameworthy. So this blameworthy mind is what we call the mens rea of an offense, and it constitutes the criminal intent. That is the intent, what the person wants to gain, the motive of that person for doing that particular act or for committing that crime. So in Abeke versus State, the court defined this concept of mens rea as the guilty state of mind. The court held that it is the state of mind which the accused must possess at the time of performing whatever conduct requirements that are stated in the Actus Reus. So the prosecution must go beyond establishing the commission of the unlawful criminal acts. They have to go beyond this, and they have to prove the criminal mind. They have to convince the court that this person committed this crime, he had intention of committing the crime. So if they are unable to prove this, the court cannot convict the accused person. So the two elements must coexist. They have to be concurrent. They have to be very contemporaneous. They have to be together. So the prosecution is unable to prove the two elements together, they cannot secure conviction. And that is the position of the Supreme Court in the case of Bolanle versus State 2009, where the court held that the two elements must be established by the prosecution before any criminal liability. For us to know how intention can be discerned, let's consider this locus classicus case of E.g. of Northern Ireland versus Gallagher. So in this case, the accused person was charged for murder. He wanted to marry another woman, so he killed his former wife, or he killed the former woman that he had so as to marry the new one. So when he got to court, he claimed that he was drunk and that was why he killed his wife. So the court now held that the wickedness of his heart, even before he got drunk, was enough to convict him. So the way the court discerned the intention in this case was that the man killed not because he was drunk, but he killed because he wanted to marry another wife, and he had to kill his first wife because polygamy is not allowed under their law. So he killed his wife because he wanted to marry another, not because he was drunk, and that was how the court was able to discern intention. So we have some words that are commonly used by the statute to represent intention or the mixture or the guilty mind of the accused. So the first of it is the intention. So intention simply means the purpose behind the accused action. That is the motive, like what you want to gain, the aim and objective of the action. That is the intention. And this can be discerned in many ways, in three ways. Like law, the court has actually established three ways of establishing intention. Number one is that a consequence is always intended if it is the aim and objective of the accused. That is, you have the aim of killing someone now. The main objective of doing something is to kill. That the court will discern intention in that regard. Then the second one is that it's just like possibility. A consequence is always intended if what you did is a natural. You can foresee that this is a natural cause of what you've done. Then the last one is that a consequence is intended when it is foreseen as probable results of the action of the accused. This third one is the one that the court always relies on because they feel like every man intends the natural consequences of his acts or the probable cause of his action. If you are using like weapon to fire with someone and that person dies, you cannot claim that you have intention of killing that person, because for using weapon alone, it will be presumed that you intended the natural consequences of your action. To understand this better, let's consider the following cases. And the first one is the case of IAM versus DPP. So in this case, the accused person poured petrol into the letterbox of her lover's mistress' house and she ignited it, knowing fully well that there were persons sleeping inside, but she continued with the action, and this resulted in the death of the persons that were sleeping inside. So when she got to court, she contended that she had no intention of causing death, but had foreseen the grievous bodily harm that is highly probable as a result of his action. The court upheld the conviction. So in this case, after the action, the woman was claiming that she was contending that she didn't have intention of killing people. She just wanted to cause the grievous bodily harm. And the court held that so far that was the probable cause of her action, then she intended the consequences. And the conviction was upheld. Another similar case is the case of Ubani versus State. So in this case, the accused and the appellants, armed with machetes and guns, went to the deceased house and he beat him till the time he discharged excreta. And as a consequence of his action, the deceased person died. So on appeal, the Supreme Court held that so far he could foresee the grievous bodily harm caused to the done to the deceased person, then that was the natural consequence or the probable consequences of his action. So far he has intended to cause grievous bodily harm. So the accused was upheld. The accused was held guilty for this action. So this was the same position in the case of Nugu versus State, in the case of State versus Idowu, and several other cases. The next way of discerning intention is recklessness, and this occurs when the accused knows that their actions are likely to result in a crime, but they proceed to continue the action. This is well stated under section 59 of Criminal Code. And a good example for this is if someone is overspeeding in the marketplace and it causes accidents. In that instance, he cannot claim the idea of intention of causing the accident because it was reckless. So that is a very perfect example for it. And the next one is the knowledge. So knowledge involves being aware of the circumstances of a crime, knowing that a crime has been committed or knowing that the property was stolen. So and this knowledge can be actual, it can be constructive, and it can be in the case of willful blindness. So this is what represented under section 167 of evidence that has stipulated that there is presumption of guilty knowledge for every person found with a stolen property, and is a representation of is in material with this doctrine under common law, the doctrine of recent possession. If someone is found with a stolen property, there is presumption of guilty knowledge that you knew that the thing was stolen. So section 319 of penal code and 247 of criminal code, they talk about receiving stolen property. The next one is the rashness, which means gross negligence. Gross negligence occurs to medical doctor in most cases, and we have negligence itself. It's just a failure to perform a duty. And the next one is voluntariness. An act is voluntary. We know that this is the outcome of your action. If someone intended the outcome, that it is voluntary. That is voluntary action. And the next one, or the last one, is the dishonesty and fraudulence. They are mostly the same. So an act done without good faith, an act done without goodwill, that is the dishonesty. It's mostly used in the case of theft or stealing. So you have to be dishonest in this instance. If you are taking someone's property that does not belong to you, dishonestly or fraudulently, with the intention of depriving the person of the ownership and the possession. So that is dishonesty.